of land is the basis on which compensation must be assessed. Your Excellencies, the compensation in this case was below the market value. That is why the residents are aggravated. Your Excellencies, the respondent submits that leasing that according to section 44, public trust assets can't be leased or alienated to private entities. Your Excellencies, it is our submission that leasing is okay, but not for financial gain, or assessment was not done. Assessment was done, but without due process. Your Excellencies, we shall also rely on the section 44, subsection 4 of the Land Act, Cap 236. I pray to submit.
Yes, thank you. So I'm seeing Council is preparing for a sorry battle, but we are in a very critical court, and we should have an end at litigation. In case you've done some civil procedure, we all know that the appellant submit, respondent submit, and then there is a rebuttal, so that there is an end to litigation. So in the circumstances, in case you are prepared for a sorry battle, kindly fix it in your submissions for the next session. For this, we cannot bend the laws, and that's something that cannot be negotiated with. We are following strict civil procedures that cannot be delegated. Yes, for that cause, therefore, we thank you for the Moot. We thank you for the session. It has been a brilliant team, both sides. I do pray that we meet on semi-finals and then finals. It's a very good team. I am not bored. I enjoy the team, though not satisfied that my case has since not been talked about. That's the case of Hajnyakana, but maybe in the next courtroom you will talk about it. We thank you very much for the resilience, for the knowledge. Truthfully, you guys are very much knowledgeable. You can actually appear in court. Yes, maybe my colleague has something to say, and then we call it a session.
Well done to all of you. How do you feel? I can say I'm very glad to see you confidently submit. If I was in your in your position, I think I would be scared. But well done. I believe you'll make it to the semi-finals, and I pray you make it to the finals. Otherwise, we have liked your submissions. Thank you for deliberating well and doing your research. All the best in your next round. Yeah.
Hello law students all over Uganda. The Uganda Law Student Association brings to you the National Land Law Moot competition at Nkumba University. Meet the judges.
Her Worship Doreen Ainembabazi, a Chief Magistrate at Kawempe Magistrate Court.
Counsel Tracy Narada, a lawyer with experience in legal practice. Counsel Nasa Konde, a lawyer at Brownwall Advocates. Hello law students all over Uganda. The Uganda Law Student Association brings to you the National Land Law Moot competition at Nkumba University. Meet the judges.
Her Worship Doreen Ainembabazi, a Chief Magistrate at Kawempe Magistrate Court.
Counsel Tracy Narada, a lawyer with experience in legal practice. Counsel Nasa Konde, a lawyer at Brownwall Advocates with extensive expertise in digital intellectual property. Counsel Takome Imran Chigongo, a lawyer, entrepreneur and civil society advocate. Counsel Nagawa Penina Noreen, a distinguished advocate for academic excellence, moot court development and student empowerment. Counsel Gwani Jordan, an accomplished moot court advocate, coach and intellectual property practitioner with extensive experience in national and international moot competition. Counsel Norbert Katsingazi, a distinguished moot court advocate and legal researcher, a former president of the Makerere Moot Society. Counsel Kasule Joseph Rogers, a legal practitioner with a strong academic and professional foundation in the law. Counsel Kasita Fred, an advocate of the High Court of Uganda and currently serving as the legal officer of the Sun Law Advocates. Counsel Muhumuza Livingstone, a lawyer, legal practitioner and a mentor with Hello law students all over Uganda. The Uganda Law Student Association brings to you the National Land Law Moot competition at Nkumba University. Meet the judges.
Her Worship Doreen Ainembabazi, a Chief Magistrate at Kawempe Magistrate Court.
Counsel Tracy Narada, a lawyer with experience in legal practice. Counsel Nasa Konde, a lawyer at Brownwall Advocates with extensive expertise in digital intellectual property. Counsel Takome Imran Chigongo, a lawyer, entrepreneur and civil society advocate. Counsel Nagawa Penina Noreen, a distinguished advocate for academic excellence, moot court development and student empowerment. Counsel Gwani Jordan, an accomplished moot court advocate, coach and intellectual property practitioner with extensive experience in national and international moot competition. Counsel Norbert Katsingazi, a distinguished moot court advocate and legal researcher, a former president of the Makerere Moot Society. Counsel Kasule Joseph Rogers, a legal practitioner with a strong academic and professional foundation in the law. Counsel Kasita Fred, an advocate of the High Court of Uganda and currently serving as the legal officer of the Sun Law Advocates. Counsel Muhumuza Livingstone, a lawyer, legal practitioner and a mentor with experience in land law, constitutional law, civil procedure, corporate and commercial law. Meet all the listed judges in the National Land Law Moot competition happening at Nkumba University on the day of 21st August 2026 at Nkumba University. Passion Media, streaming live on the Passion Media. Hello law students all over Uganda. The Uganda Law Student Association brings to you the National Land Law Moot competition at Nkumba University. Meet the judges.
Her Worship Doreen Mbabazi, a Chief Magistrate at Kawempe Magistrate Court.
Counsel Tracy Narada, a lawyer with experience in legal practice. Counsel Nasa Konde, a lawyer at Brown Wall Advocates with extensive expertise in digital intellectual property. Counsel Takome Imran Chigongo, a lawyer, entrepreneur and civil society advocate. Counsel Nagawa Penina Noreen, a distinguished advocate for academic excellence, moot court development and student empowerment. Counsel Gwani Jordan, an accomplished moot court advocate, coach and intellectual property practitioner with extensive experience in national and international moot competition. Counsel Norbert Katsingazi, a distinguished moot court advocate and legal researcher, a former president of the Makerere Moot Society. Counsel Kasule Joseph Rogers, a legal practitioner with a strong academic and professional foundation in the law. Counsel Kasita Fred, an advocate of the High Court of Uganda and currently serving as the legal officer of the Sun Law Advocates. Counsel Muhumuza Livingstone, a lawyer, legal practitioner and a mentor with experience in land law, constitutional law, civil procedure, corporate and commercial law. Meet all the listed judges in the National Land Law Moot competition happening at Nkumba University on the day of 21st August 2026 at Nkumba University. Passion Media, streaming live on the Passion Media. Hello law students all over Uganda. The Uganda Law Student Association brings to you the National Land Law Moot competition at Nkumba University. Meet the judges.
Her Worship Doreen Mbabazi, a Chief Magistrate at Kawempe Magistrate Court.
Counsel Tracy Narada, a lawyer with experience in legal practice. Counsel Nasa Konde, a lawyer at Brown Wall Advocates with extensive expertise in digital intellectual property. Counsel Takome Imran Chigongo, a lawyer, entrepreneur and civil society advocate. Counsel Nagawa Penina Noreen, a distinguished advocate for academic excellence, moot court development and student empowerment. Counsel Gwani Jordan, an accomplished moot court advocate, coach and intellectual property practitioner with extensive experience in national and international moot competition. Counsel Norbert Katsingazi, a distinguished moot court advocate and legal researcher, a former president of the Makerere Moot Society. Counsel Kasule Joseph Rogers, a legal practitioner with a strong academic and professional foundation in the law. Counsel Kasita Fred, an advocate of the High Court of Uganda and currently serving as the legal officer of the Sun Law Advocates. Counsel Muhumuza Livingstone, a lawyer, legal practitioner and a mentor with experience in land law, constitutional law, civil procedure, corporate and commercial law. Meet all the listed judges in the national and law moot competition happening at Nkumba University on the day of 21st August 2026 at Nkumba University. Passion Media. Streaming live on the Passion Media.
Much obliged, my lords. My name is Marion Ketakoli, Attorney General for the Republic of Gonja. Mr. Alex Olengo appears as counsel for Chanja Holdings Limited, representing the Nambaja Community Association. We have Namirimu Harriet Pauline and Mr. Yangu Richard Alem.
Thank you so much. Could you send your names, like written down, like write your names and send them? And then to the clerk, we need more papers. Scoring sheets. No scoring sheets. I do know. Okay, you can proceed.
Counsel, the Attorney General of the Republic of Gonja, Namirim Harriet Pauline, appearing on behalf of the appellants, together with my co-counsel, Yangu Richard. My lords, we are appearing on behalf of Nambaja Community Association,
What's your team code? Your team code.
LNM 005. Much obliged, my lords. My lords, I pray to be guided on the time that I am supposed to use. Much obliged.
You have 30 minutes, so I don't know how you're going to divide among yourself.
Much obliged, my lords. My lords, I'm going to use 17 minutes of this court's time. My co-counsel will use 10 minutes, and we shall reserve the 3 minutes for rebuttal. Much obliged, my lords. My lords, as earlier stated, we are appearing on behalf of Nambaja Community Association and others. My lords, before I proceed any further, I would like to recognize the jurisdiction of this honorable court. My lords, jurisdiction is a creature of statute, as it was established in the case of Baku Raphael versus Attorney General, Constitutional Appeal number 1 of 2005. My lords, the Supreme Court stated, the court stated that the right to appeal is not inherent, but rather it should be expressly stated by law. And my lords, pursuant to that, Section 66 of the Civil Procedure Act mentions it that this Honorable Court of Appeal can hear or can redetermine on the decrees made by the High Court. Much obliged, my lords, and the procedural competency of this Honorable Court is listed in Order 43, Rule 1 of the Civil Procedure Rules, read in conjunction with Rule 75 and 76 of the Judicature Court of Appeal Rules, my lords. And my lords, since this is a first appellate court, it is vested with the duty to re-evaluate and reconsider the decision of reconsider the evidence as it was provided in the High Court and come up with its own decision as it was established in the case of Chifamunte Henry versus Attorney General versus Uganda, my lord, which is a criminal appeal number 10 of 1997, my lords. And my lords, I therefore conclude by saying that this Honorable Court is seized with the powers to reconsider the decision of the High Court and determine the questions of law and fact which arise therefrom, my lords. Much obliged. My lords, I beg to proceed to the statement of facts unless advised otherwise.
Proceed.
Much obliged, my lords. My lords, this is an appeal which is arising from the miscellaneous application which was filed in the High Court of Gonja, my lords, by the Nambaja Community Association. My lords, this application arose when
my lord. Much obliged, my lord. My lord, in reference to Article 26 of this Constitution of the Republic of Gonja, it recognizes the right of every citizen to own land either individually or in association with others, just like the customary areas within Nambaja. They own land in association, not individually, my lord. And my lord's father, the Article 26, Clause 2, limits the powers of the government in acquisition of the land, my lord. It says that in case the government is to acquire land from the people, it must first fulfill two undisputable conditions, where that acquisition must be necessary for a public use or public safety, and it must be made under a law which provides for the prompt payment, which is very fair and adequate, my lord. And therefore, my lord, the land trial judge, by permitting the state and its proxy, Chanda Holdings Limited, to take over the people's land before adequate compensation is made, was indeed an error of law. It was contrary to Article 26 of the Constitution of the Republic of Gonja.
Council.
Much obliged, my lord.
Is Article 26 a derogable or non-derogable right?
My lord, it is a derogable right.
So in the circumstance, under what circumstances can you do away with it?
My lord, you can do away with it in cases of public interest or for public safety, my lord.
So in relation to the facts, is this in public interest or these people have been actually compensated and we're just wasting the court's time?
My lord, it was in public interest as per paragraph 5 of the...
What's public interest?
My lord's public interest is where the government is going to carry out a plan which is mainly going to benefit the residents or the citizens of the country. For example,
in the circumstances, what's benefiting?
My lords, in relation to our facts, this project was intended to secure like 30,000 jobs to the people of Nkumba province.
So, what's your submission therefore? What is your submission therefore?
My lords, I therefore submit that although this was to benefit the public, but it would have been done in the way, it would have been done in a procedure as per the provisions of Article 26, my lord.
What was not done?
My lords, there was inadequate compensation to the people of Nambaja, and my lords, the element of promptness.
Council, you can take some water.
Much obliged, my lords. Much obliged, my lords. My lords, the land trial judge, when he was also making his decision, did not take into consideration the principle of promptness as listed in Article 26, Clause 2, my lord. It requires that before possession is taken, there must be prompt payment immediately. The land to be used for other purposes. And my lord, I beg to much obliged. And my lord, I beg that this honorable court be persuaded by the case of Fairali Abdurasul versus Adrian Sibo, which was cited by the appellants. However, the land trial judge did not consider the principle in this case. My lord, the principle in this case was that the court emphasized that any pending valuations cannot justify the deferral of payment while the project advances, my lord. The payment should first be done, and then it can proceed, the government can proceed to use the land. And my lord, in relation to our facts as on paragraph 16.
So was there payment made?
My lord, I pray to take you to paragraph 15 of the statement of facts in order to answer that question. Paragraph 15 on page 4 states that where ownership disputes arose, the government deposited compensation monies in court and proceeded with implementation pursuant to the UCSIA. My lord, it continued with the use of the people's land before the disputes which were relating to compensation were fully resolved. It means they did not respect the element of promptness as per the provision of Article 26, my lord. Much of that, my lord. My lord, also the land trial judge did not take into consideration the provisions of Section 78 of the Land Act, which mandates that in any case of Much of that, my lords. My lords, unless advised otherwise, I beg to proceed to round number 2. Much of that, my lords. My lords, in this round number 2, I'm going to indeed affirm that this the trial judge are in law and in fact in finding that the interests and rights of the bona fide occupants, the lawful occupants, were not followed. That the land trial judge are in law in finding that the interests, rights of the bona fide occupants, lawful occupants, was followed adequately. My lord, the land trial judge committed a fundamental error of law by saying that they were followed, yet they were not, as it is stated in his decision on paragraph 27, my lord, on page 6 of the first, my lord, paragraph 27, line 3. The land trial judge stated that the rights of lawful occupants, bona fide occupants, and customary owners had been sufficiently considered, which is not as per the law, my lords. My lords, my lords, bona fide occupants in relation to section 29 of the Land Act are those people who have lived on the land and cultivated on it uninterrupted by the owner for more than 12 years before the coming into of the 1995 Constitution. Much of that, my lords. My lords, further, Article 237 clause 8 of the Constitution of the Republic of Uganda mandated the Parliament to come up with the law which permitted the existence of the lawful and bona fide occupants, and that's why, my lord, we have the cited section 29 of the Land Act, my lord. And my lord, to proceed further, the Land Act Part 236 under section 31 prohibits the deprivation or the eviction of these lawful and bona fide occupants without a competent court order, or prior payment of adequate and fair compensation. Therefore, my lord, the land trial judge erred in law by failing to recognize the provisions of the Land Act and held that, indeed, the rights and interests of the people of Nabanda was followed, specifically the lawful and bona fide occupants. Much of that, my lord. My lord, to proceed still further, Article 30, I beg my pardon, my lord, Section 36, subsection 3 of the Land Act specifically mentions that in case land is being sold, the tenant on that land should be given.
I think you are aware that we are the part of the bill.
Yes, my lord.
And we don't need to go into those sections because it's an appellate court with the presumption that the judges of this bench understand the law. So I request that actually you delve more on making us understand where the trial court or circumstances where you think the judge will not consider the evidence at hand. Because the law is not clear. These sections you cited them in high court. Right? So I need to understand what's the gap between your understanding the law and the trial judge's understanding the law.
Much of that, my lord, to submit on that, the land trial judge, the appellant cited the case of Kampala District Land Board.
Who are the appellants?
My lord, asked when we were in the court, the trial court.
So I think cited that in the lower court.
Yes, my lord. We cited in the lower court, we cited the case of Kampala District Land Board and Chemical Distributors versus National Housing and Construction Corporation. My lord, in this case, the Supreme Court made it clear. The Supreme Court made it clear that any allocation of land by a land board or any state authority that ignores or overrides the interests of the current tenants or occupants of the land is a nullity, my lord. The land trial judge did not consider the provisions in this case and therefore came up with an absurd decision that the rights and interests of my clients were indeed followed adequately.
So is that case binding or persuasive?
My lord, it is binding since it is from the Supreme Court. Much of that, my lord. My lord, I therefore propose that this honorable court reconsider that decision my lords. Much obliged, my lords. My lords, to conclude on this ground, we urge this honorable court to set aside the decision of the land trial judge and rule that the rights of these occupants were systematically and unlawfully followed. Much obliged, my lord. My lord, being of no further indulgence, the honorable court. Much obliged, my lord. Yes, my lord.
Make your prayer.
Much obliged, my lord. My lord, I pray that this honorable court overturns the judgment of the land trial judge. Dismiss the legality of the UTS IA, which did not conform with Article 26 of the Constitution, my lord. My lord, I also pray that this court orders for a fresh compensation evaluation in order for my clients, the residents of Nkumba, to receive fairly and adequate compensation, including the disturbance allowances, my lord. And I also pray that this honorable court orders the respondents to pay costs for this appeal, my lord, and the courts at the trial court. Much obliged, my lord. Being of no further indulgence, I will ground my co-counsel, young Richard, to dissect ground number 3 and ground number 4 of this honorable court. Much obliged, my lord.
My guidance was that the High Court judge did not take whatever he or she did in her or his hands. Get my point? So let's use language that...
My Lord, in the land judge's decision, he did not put into consideration the provisions under Section 43 and 51 of the Evidence Act. That may require an expert opinion in coming up with a very partial decision in regards to the grant and approval of that particular project by NEMA through its impact social assessment, through its environment social impact assessment, which is conducted.
So how did you conduct the impact and environmental impact assessment?
My Lord,
How did you want it to be conducted?
the social impact assessment, in doing so, since the project is involving the public being forced to be taken into consideration because the project, the land itself, is put in trust by the public to the government by the people themselves in as far as the 237 clubs is concerned. Meaning that the government also considers public participation in as far as assessing this land is concerned, putting in context the constitutional rights and interests that they have in this land.
Do you have a case for that?
My lord, this particular provision then has been affirmed in the case of Kasule versus Kayonga in 1990s, where the judge said that the rights of these particular individuals have to be considered no matter what, and that participation is not just merely, it's not furthermore, another place was laid down again by my lord to support this provision in the case of British American tobacco versus the Environment Action Network. That was brought to the lower court, and it was a high court decision that was merely binding in the lower court. The judge will take into consideration. The place we stated that the right of public participation in as far as grant is concerned is not merely an administrative courtesy, but rather it's a mandate that they ought to be followed.
Yes, thank you. Council, which projects require impact assessment?
The use of the wetlands in as far as the Great Akara Integrated Development Project is concerned.
So if you look at some of the prayers, you indicate and claim that there is that traditional heritage that you want to preserve. Is it part of the wetland or is it independent?
My lord, the land, the traditional heritage site is part of the land, not part of the wetland that I then be talked about in as far as the environmental assessment act was concerned.
So in this you agree that government can demolish the traditional site
that was the prayers of the applicants, my lord. Because the land is the effect that was supposed to assess what I
Council, I choose my words very much clear. And the question is, do you think they should actually proceed with the construction and demolish the heritage site but leave the wetland around?
No, my lord. Because the law is the effect that even natural sites are being protected.
What law is that?
My lord, when you look at the provisions of the law under section 13 of the National Tree Planting Act, it provides a ground that the government has to take full responsibility in protecting the ecological system, in ensuring that even the plants, the wetlands, and so other acts that are to be given by the people in the government. So in that ground, then the government also consider all these grounds in ensuring that then this assessment is taken to be valid.
Council President.
My lord, moving forward, my lord, we realize that the land law is not taking into account the principle of requiring an expert opinion. They also not putting into consideration that the section 23 of section 23 and 58 of the Federal Agreement provides for that. It then means that the land law are the law and public can not legislate the law.
So you're saying getting an expert opinion and also having an impact assessment, as I said?
Having an expert opinion, it is to give ground for a judge to determine whether indeed the assessment that was conducted by NEMA then would negatively affect the people in line with implementing the project or not.
So you're not calling it an impact assessment, you're calling it an expert assessment?
Yes, an expert assessment as per the provisions in section 23.
Why don't you refer to an impact assessment?
My lord, because in this case, we're even challenging also the assessment that was inadequate and wasn't properly done.
Okay, Land Council, do you think there is a difference between an expert report and the development assessment?
My lord, I do believe that there is a difference. Because
in the circumstance, did you conduct any other independent assessment?
yes, my lord, according to the facts, under page 5, paragraph, under page 5,
No, I don't need that. My question is, yes,
it was done by the environment organization that looked upon it and came up and said it was denied.
kindly proceed.
Imagine that, my lord. My Lord, that not been put into contention by the federal judge. Then the land federal judge didn't argue on fact by not putting that into contention, my Lord. Based on that, we therefore pray that this honorable court, then if it evaluates the evidence that provided in the lower courts and come up with its own decision, that in this case we pray that it should be in favor of the appellant. Much obliged, and therefore proceed to ground 2. The ground 4 is much obliged. My Lord, ground 4 basically is to determine if the land federal judge was able to put the balance of competing interests of both constitutional land rights and then the community rights. My Lord, in this regard, in the draft implementing the project, my Lord, when you look at the realm of Article 237 allows for, that then, when you look at the realm of Article 237 allows for, it permits the government to take into possession in trust on behalf of the people, wetlands, forests, and any other such property that will be given to them in trust of the people. My Lord, these properties are being owned by the people in as far as the principle of public domain is concerned. Meaning that the government here has a duty to keep this property in trust of the public. Now, we also put in contention that the law is supposed to grant the government the permission to use this particular property, this particular land, if at all it's for the interest of the public. But however, Section 3 of the Land Act, or the Land of Use Act, then provides that if the government then intends to use this land for public interest, the government also take into consideration public participation and also take into consideration what we call as the rights of these individuals on this land, my Lord, which then in the federal decision, such was not taken and was not evidence abused by the requirement. This simply means that the land judge just trying to consider what they was.
Kindly make a prayer in relationship to the ground. I'm saying kindly make a prayer in relationship to the ground, and then we proceed. Make your prayer.
My Lord, dealing with the fact that in the land project is not critical in consideration, and I just pray that on ground 4, this is not because they find that indeed in so doing, and so coming up with a decision by the federal judge, he did not then consider all the necessary laws and then add in law and fact in the coming of that decision. And therefore we pray that the honorable court, once that decision comes up with its own conclusive decision on this particular ground, and then we pray that it comes to the side of the appellate. Much obliged.
Okay, let's do this one. Alright, now, at first it was a question. Then court orders, kindly tell court something in relation to the amount. Alright, thank you.
If it may please this honorable court, my name is Akoli Marian Kate, Attorney General for the Republic of Gonja. My lords, I will use 15 minutes of this court's time to respond to the appellant's allegations in grounds 1 and 2. Unless directed otherwise, I shall proceed. My lords, the government of Gonja has put forward its best foot in trying
Who are you representing?
Much obliged, my lord. As the Attorney General, I represent the Republic of Gonja.
So, at here in the lower court, did you have joint instructions or the second respondent just happened to the court? At the lower court, did you have joint instructions? Did you represent the second respondent or otherwise?
Much obliged, my lord. At the trial court, I represented the Republic of Gonja, while Mr. Alex Solengo represented Chanja Holdings Limited as its counsel.
All right, okay, thank you. Kindly.
Much obliged, my lord. My lords, the government of Gonja has put forward its best foot in trying to compensate the individuals of the Nambaja community. It equally went ahead to make sure that it complied with all pertinent environmental law considerations, considered the sacred nature of their culture, and went ahead to grant a 99-year lease to the Chanja Holdings Limited with the interests of the individuals of not only the Republic of Gonja, but specifically the members of the Nambaja community at heart. My lords, the respondents concede to this court's jurisdiction to hear this appeal. In response to ground one of the appeal, my learned sister laid down the allegation that compensation that was awarded to the members of the Nambaja community was inadequate. My lords, she went ahead to cite Article 26 of the Constitution, which provides for the right to property, and acknowledge that this right is indeed a derogable right. My lord, to that we do not contend. However, my lords, my learned sister went ahead to rightfully so direct the minds of this court to the case of Pirali Abdul Rasul versus Adrian Sibo, which is a constitutional petition number 9 of 1997. My lords, that case is immensely clear on the measure of adequacy. My lords, that case lays down the prerequisites that the measure of adequacy is based on the market value of the land, which was rightfully identified by my learned sister. She then went ahead to cite the case of Shema Cooperatives versus the Attorney General. However, my lords, I beg to correct this court on the importance of that particular case. My lords, Adrian Sibo, when read in conjunction with the case of Shema Cooperative, brings out one important aspect that I beg this court to put into due consideration. When those two cases are read together, my lord, it brings together the fact that in instances of compulsory acquisition, a market value must be obtained. This market value is obtained through the records of a competent government valuer, which indeed in this instance was done as viewed under paragraph 14 of our facts. However, my lord, the case of Shema Cooperatives comes out to drive the minds of the court to instances where there is a dispute in the value that has been given by the chief government valuer. Indeed, in our particular case, there was a dispute. However, Shema Cooperatives comes out to say one thing, one important thing, that where such dispute arises, then an independent valuer must be obtained in order for a particular value to be agreed upon. My lords, I beg to bring it to this court's notice that all of this was indeed done, and that is why the values at which we compensated these particular individuals of the Nambaja community was held to be sufficient by the High Court when we refer to Court Order number 2 on the High Court ruling. My lords, it is therefore in that regard that the report that was granted by the chief government valuer was held to be immensely adequate. However, we as the Republic of Gonja did not end at that. We went ahead to make sure that each and every person who had a grievance against the government's compulsory acquisition had redress. I beg to direct the minds of this court to paragraph 15 of the facts, where the government even went ahead, my lords, to deposit such monies in court.
Yes. I appreciate that you are being that way. But in circumstances, don't forget the fact that you are government, and government is the people. The circumstance where government, where the people believe actually that compensation was inadequate. What did you do in premise to avoid litigation?
Much obliged, my lord. My lord, I beg to refer this court to section 6, subsection 5.
Counsel, what?
Much obliged, my lord. My lords, indeed, I beg to refer this court to page 5 of
to page 6 of 8 of the facts on record, where, my lords, it states under court order number 2 that the government had complied with every requirement governing compulsory acquisition. It is in that regard, my lord, whereby all requirements in relation to compensation monies, in relation to prompt, fair, and prior payment of these monies, in relation to bringing it to their notice that the government intends to acquire this land, was very much followed, my lord. Addressing.
I do appreciate that, and that's what it is. But the people you lead are saying, look, no, that's fine. So what have you done as government? This is a very tax. This is a body in Uganda. These people elected your government into power. So in this, you want to sweep them under the carpet and proceed because the parliament enacted some law. That's one. Two, both know that Article 6 is not correct. In any way, it can't be reconciled. But it's not saying this should be considered. Right? So my question is, we talk about fairness. Fair. Because this is a young lady in that video. That lady draws sustenance from the countryside. That person is growing young. Food that actually keeping the environment. You want to construct a road. And you want to construct a road. And in constructing that road, you are going to destabilize the ecosystem. So this is what have you done? What have you done? Did you conduct some assessments, sit down with these people, and then understand the performance of what you are doing?
Much obliged, my lord. My lords, the learned judge has rightfully made reference to Article 26 of the Constitution of the Republic of Gonja. My lord, that particular provision in relation to derogating from that right provides that such projects must be in the public interest. My lords, I beg to direct the minds of this honorable court to paragraph 4 of our facts, where the government went ahead to, first of all, identify the respective interests that are existent on the land currently. The government went ahead to identify all of the project-affected persons. However, my lords, the government did not end there, putting into consideration the fact that this particular project is very much so in the public interest. My lords, I beg that we put into consideration the current challenges that are being faced by not only the Republic of Gonja, but smaller marginalized communities like the members of Nambaja Association, which are provided for in paragraph 1 of our facts. Currently, the Nambaja community faces population increase. My lord. Population increase comes in with a number of trials and tribulations. However, the government saw it right to compulsorily acquire this land, not merely to construct a road, my lord, but to go ahead, as seen in paragraph 2, to modernize transportation networks, provide affordable housing for the individuals here, go ahead to establish industrial parks. In fact, my lord, paragraph 5 goes ahead to show that with this project, we are going to create over 30,000 jobs.
Yes. If you look at this, I understand, but did you tell me, did they understand? They are getting jobs. Yes or no?
Much obliged, my lord. Indeed, we did make them to understand the depth of this project and the various benefits with which it will come.
So, in relation to their claim, do we agree that actually that was an
Much obliged, my lord. We do not agree that the compensation that we awarded to these individuals was inadequate.
We are blessed that we have the Attorney General talking in court here. What do you have for these people? We make this together. What do you have for these people?
Much obliged, my lord. My lords, in relation to the guidelines on compulsory land acquisition. It states that in instances where land is compulsorily being acquired, then the government must put into consideration the one and only restitution principle, which means that in situations whereby we are compulsorily acquiring their land, we should look at means of restoring their livelihoods. We should look at means of restoring them back to the position in which they were before this property was acquired. And indeed, my lord, this is something that the government is currently progressively realizing for the better future of not only the members of the Nambaja Community Association, but for the entire Republic of Gonja. Much obliged. Much obliged, my lord. Public interest is not in any way meant to affect the rights of these individuals. However, my lords, it is worth recognizing that in instances whereby a government is setting up a project that is going to directly affect the persons, there may be a little bit of present discomfort. However, the Republic of Gonja has recognized the best international practices. My lords, much obliged, my lords. The Republic of Gonja, in the institution of this project, went ahead to make sure that no individual was left in a point of limbo. And that is why we went ahead to compensate them, not only monetarily, but we went ahead to make sure that even their lives afterwards were surely not one of suffering. Much obliged, my lord. In response to my learned sister's allegations under ground 2 of the appeal, my learned sister alleges that the rights and interests of the affected members of the community were not sufficiently considered. She further on goes on to state a particular section in the Land Act which provides for non-eviction of these occupants. My lords, I beg to direct the minds of the court to paragraph 4 of our facts, where the government of Gonja went ahead to identify each and every one of the individuals that had contention on this land. We went ahead to identify them as project-affected persons. My lord, we recognize the rights of the bona fide occupants, the lawful occupants, the customary owners who are supposed to hold their land as a community. We went ahead to even recognize the rights of the registered Milo land owners, my lord, and we did not leave them without redress, my lord. In this process, we went ahead and made sure that each and every one of these individuals was compensated for whatever interest they had on the land. My lord, in situations where ownership disputes arose amongst any of these individuals, we recognize those disputes, and it is for that reason as to why we went ahead to make sure that monies were furthermore deposited in court. My lord, my learned sister.
Counsel, do you think you can reconsider some of the prayers made by the appellants so that the matter can be resolved? Because the government and they seek your assistance. So do you think, besides the activities of law and provision, do you think that there is any way as the government who can sit and have this matter resolved?
Much obliged, my lord. Amicable resolution for this matter has its answer in the confines of Shema Cooperative versus the Attorney General, where
my question was a discussion. You are discussing the age, not necessarily citing the religion. Do you think this, as government people, you can have this matter resolved on a win-win situation?
Much obliged, my lord. Indeed, it is possible to resolve this matter on a win-win situation where the government continues development for the betterment of the Republic of Gonja, while the individuals are not left at a total loss. And such resolution can come in by sitting down and having a re-agreement on possible figures that the members of the Nambaja Community Association may or could have expected from the government. Much obliged, my lord. It is the respondent's prayer that this honorable court upholds the decision of the learned trial judge to the effect that Article 26 of the Constitution was duly complied with, and that the interests of the lawful occupants, bona fide occupants, registered Milo land owners, and the customary owners were duly put into consideration. If I have no further indulgence to this court, I beg to yield the floor to Counsel for Chanja Holdings Limited, Mr. Alex Olengo. I so submit.
Thank you very much.
It may please this honorable court, as my colleague has mentioned, I am Alex Olengo, counsel for the second respondent, Chanja Holdings Limited. I will use 15 minutes of this honorable court's time to respond to ground 3 and 4 of the appellant's allegation. My lord, Chanja Holdings Limited conducted an environmental impact assessment, which was approved by the statutory body, which was approved by NEMA. My lord, I shall now proceed to ground 3. An environmental and social impact assessment is the evaluation of the impact that the proposed project would have on a project, my lord.
So the duty for the project is more negative.
My lord, paragraph 5 of the fact states that the project would provide more than 30,000 jobs. It would improve the households of the community, because remember, there is a bulging population within the community of Nambaja. So this project has more of the benefits vis-a-vis the downside.
I'll ask a question and ask you to So, public interest over projects, like projects development, would you go ahead with the public interest and affect other people's rights?
My lord, the project has more benefits compared to the grievances of the minority within the society. And this is why we strongly suggest that the allegations of the appellant should not be entertained by this honorable court.
Okay, could you give us a reason for that?
I'll refer to fact number 5, my lord. Much obliged, my lord. My lord, I shall now proceed to ground 3 of the allegation, where the land colleague, Richard, alleges that the land trial judge erred in law and in fact in holding that the approval and the implementation of the project complied with the environmental laws, with the principles of sustainable development, and with the protection of wetlands, ecological systems, and the cultural heritage sites. My lord, the second respondent submits that the land trial judge did not err in law and in fact with regard to the ground. My lord, I shall respond to the allegation made by the land colleague under ground of argument, compliance with environmental laws, and public participation. My learned colleague, Richard, seems to base his argument on Section 43 of the Evidence Act. My lord, I would like to bring to the attention... Yes, my lord.
I understand the reply, and as but I want to let you participants know that this is a good provision. There's presumption is you are the same people that argued the matter in the lower court. So we don't need much more to go into the deep of sections. And I understand your opinion. But the fact is, just let this court understand that actually, unlike what they're saying, you did what is supposed to be. You know, in court of appeal, we don't mainly focus on these sections. Because the presumption is, for example, now, because in our court of appeal, you find justices that are really people that have told law, legislated law, and did everything. So the thing is, make us understand why you think you can decide something with your government. Because we are against the agreement and you have to share. But the question is, and you consider the rest of the factors. You know, what are you going to do with the right to the ground? Are you ready to coexist with it? You are ready to coexist with the right? So I'm saying, make us understand. What are you planning?
Much obliged, my lord. My lord, I was basing my argument under compliance to the environmental laws and public participation regarding paragraph 19 of the facts. Paragraph 19 of the facts actually states that an environmental impact assessment and social impact assessment was carried out by the second respondent and forwarded to NEMA, the National Environment Management Authority, a statutory body governed by statute, competent, my lord, and that is why I was of the view that Section 43 of the Evidence Act does not apply because it forms an opinion. It speaks to giving court an opinion. An opinion is discretionary, my lord. It does not bind court. My lord, Article 237 2B of the Constitution of the Republic of Gonja speaks to the very heart of the public trust doctrine, which requires that the state must manage wetlands, putting into consideration the impacts that it might create to those very ecological sites. My lords, as I mentioned earlier, the environmental and social impact assessment was approved by the statutory body, a competent body. My lords, moving to my second head of argument under ground 3, which concerns the allegation, the state's obligations to protect the ecological sites, the state's obligation to protect the wetlands and the cultural heritage sites. My lords, paragraph 22 of the facts elucidates that the relocation of the Chanja sacred grounds will give way for the project to take effect. In fact, this is a direct recognition of the rights and the culture of the people as enshrined in Article 37 of the Constitution of the Republic of Gonja. My lords, furthermore, paragraph 5 and 2 of the facts state that the project will actually provide more than 30,000 jobs to the community members and contribute to Vision 2040.
Council, that is not a mistake. And we are all invested by your PLIs in our village. But we are saying, look, for us we don't want because our heritage site is going to be removed. So what do you have for the people who believe that thing should not be removed? What do you have for the people that think you've not involved them enough for them to be okay with the development?
Much obliged, my lord. My lord, the right to culture and the preservation of culture is not in dispute. The project is recognizing the culture and the practices of the local community. However, they have even suggested that they have a specific site where they are going to relocate them to.
in the spirit of development, my lords, and in the spirit of community development, I find the allegation by the land colleague a bit dubious, frivolous, and vexatious. In other words, in fact, entertaining this appeal, my lord, would leave us on the very tight rope of jurisprudence.
Councillor, don't preempt my decision. However, my point will go back. The question that I asked the Land Attorney General. So, do you think this thing can be resolved without us coming up with a loading and awarding process?
My lord, the issue at stake can entirely be resolved.
All right, make your prayers.
My lord, we pray. It's upon this that the second respondent prays that this honorable court upholds the decision of the High Court under Court Order 4 and 5 of the High Court decision. My lord, I will proceed to round 4. I shall now proceed to round 4, where the appellants allege that the land trial judge erred in law, and in fact, in considering that the concession agreement struck a lawful and proportionate balance between the constitutional land right and the foreign investment. My lord, I will handle round 4 under 2 heads of argument. That's the constitutional land rights, and the second head of argument will be the foreign investment and the common interest. My lord, I would like to bring to your attention Article 26, Clause 1, which protects the right to own property. Clause 2 of Article 26 expressly allows compulsory acquisition upon fulfilling the constitutional safeguards. My lord, in the Supreme Court decision of UNRA, the International Roads Authority versus Asuman Irumba and another Constitutional Appeal number 2 of 2014, it emphasizes this constitutional protection under Article 22. My lord, public interest and constitutional land rights are not mutually exclusive, as the government can compulsorily acquire land for the benefit of its very own community. My lord, it is upon this that the second respondent prays that this honorable court upholds the decision of the High Court under Court Order 2, 5, and 6 of the High Court decision.
Council, the circumstance that the prayer has that you have how do you exist with these people in this village? That we won this case and answered in the affirmative. How do you think you're going to do it?
Much obliged, my lord. Coexistence is very important, as sustainable development has been defined in Section 2 of the National Environment Act and also the Black Law Dictionary as economic development that meets the needs of the current generation without compromising the future generation from meeting their own needs.
Right, thank you. You done?
Let's have the general prayer, my lord.
Please.
Much obliged, my lord. Our general prayer, the second respondent, is that we pray that the court upholds the decision of the High Court and that the court dismisses the appeal with cause. If I am of no any further indulgence, my lord, I beg to yield the floor.
So, you people want this bill, who are to give the argument first. Okay. Yes, everybody.
Attorney General, my lord, the land attorney compensation, my lord. But my lord, in my submission, I quoted section 78. After this adequate compensation has been made, section 78 requires that there should be an additional disturbance allowance, which was not accorded to by the state. Much of that, my lord. My lord, my co-counsel will also submit. My lord, we have reserved 3 minutes for our time. Much of that,
My lord, one thing that the respondents when the applicants in this case are trying to find a way that in them implementing the project, then their actions will then affect the rights of these people. Secondly, that then even this project then is going to benefit also the people of Nkumba in the future, and then can they follow the procedure requirements. My lord, Article 26 will need also guarantees that for example can acquire land. But then it is subject to decision that in doing so, and you follow the procedures that are required, and that is what the applicants have to look at. That if they follow the procedures, which we say no, they do not follow all the procedures that are required as from earlier on. Secondly, my lord, the respondents, they don't put into context that even this particular people who own this land in this particular businesses, some of them are applied already, meaning that nobody knows whether that process was obtained or whether they have been compensated. Nobody knows. But they don't even provide that. They are supposed to, as respondents, then file what you call as any originating sum of code to ask code for them to use this money under order 37 of the civil procedures rules, my lord. Which then in this case, they did not even produce, my lord. Secondly, to move forward, my lord, they didn't also propose the relocation that was broken. But in this case, the people rejected the relocation because the relocation was too remote to the extent that not even voted in this particular community is accessing. Now, if the proposal was to be that people always access, then the people of Nkumba will not have any problem against that. The other relocation was in a way that everyone knows what is the access that particular place, my lord. So if a very good proposal is brought on board, then they wouldn't have any objection. My lord, I don't know.
Thank you. I'm sorry, but I have something from the land researcher. Kindly tell us something.
Much obliged, my lord.
It's not just sorry, but we are everything off. And for me, I think everyone should have something to tell us.
Much obliged, my lord. My lord, I would like to take this chance to comment about the grand scheme of things.
You're not commenting, you submit.
To submit about the grand scheme of things. The Republic of Gonja is a developing country. And just like so many other developing countries, it's experiencing a phase of rapid infrastructure development. Of course, the citizens of this republic are going to be happy tomorrow. But our role as government today is to carry them through this process, because tomorrow they will still thank the state government. It comes at a cost, and perhaps they need to pay.
Yet you want to cost. Okay, thank you very much. That's much good. I appreciate the fitness. I appreciate the fact that you actually grasp the case. You know the case, you know the position. I commend on the submission side, you understand that your client is a vulnerable person, is a victim, is a person who needs assistance. And also the other side, they understood that this is government and they actually, this is actually general and then an investor that do not care whatever happened as far as the project goes on. I appreciate that. You know, it's good to know who your client is. And it's good to know the level of arrogance that it is to submit and also the level of softness it is to submit. That's very excellent and I will commend people. That is both of them good. I really very much appreciate. And I hope to see you on the next level in case I educate them better. I hope my ruling is not in any way influenced by anything, but people are good. And yes, judging will be less than to deliver the documents.
Good afternoon to all of you. Hope you're fine. I want to say that I want to thank the teams that have submitted. And I'm very happy to see the ladies in the panel. Usually ladies here to Moot. You in the back, you guys in the background. If you're a lady and you're not Moot, come up with yourself. I'm not being feminist, but very many women here are feminist. I'm happy to see you here. Well done to both the females and the males. I think so far that we have interfaced with my colleague have been good. This courtroom has had good teams. I pray that all of you, the 4 teams that have faced, make it to the semi-finals. And none of you maybe will be the winners. Otherwise, well done.
to immediately, having finished the 2 rounds in this court, the Mooters, you will direct yourself to the law school. You're going to have a snack as the judges compile the semi-final, the preliminaries results to come up with who will go to the semi-finals. And for us, they are preparing lunch for us. So please, let's be patient, and when that time comes, we shall announce. For now, I want to recognize the presence of the Guild President of Nkumba University, His Excellency Martin. Please, thank you so much for supporting the law school, and if I was here, I wouldn't have sat behind there, but we appreciate it. For now, we ask that we take a brief break, and the Mooters go to law school, get a snack, and then we shall know the next program. Much obliged.
You were sweating. You were just sweating. The guy was crushing you.
But the was asking question, even at that point, that voice of it is talking.
He started asking us the first. She did it, she told me there was. Josh. She did
Serious business.
Tugenda bawa HDMI. Ngaji tujjako TV. Tugenda kuta TV twale waggulu. Muda mufaidi. Tugira session emu. Tugira session endala emu. Tugira tujja kukala kitegeeza.
Yoshi. Tufuye kukulia HDMI. Bino byonna byenkola biri reflectinga
tugenda eri ku restaurant.